Hello, in today's court, Allahabad High Court directs FIR against Rahul Gandhi in British nationality. The court found a prima facie case against Gandhi and gave liberty to the state for refer the investigation to the central government or the Central Bureau of Investigation. In this case, the Allahabad High Court on Friday directed the registration of first information report against leader of opposition Rahul Gandhi in connection with the case, alleging that he is a British national holding a UK passport. Single Judge Justice Subhas Vidyarthi passed the order. The court found a prima facie case against Gandhi and gave liberty to the state to refer the case to the central government for its investigation by the Central Bureau of Investigation. The complaint filed by S. Vignesh Shishir from Karnataka sought registration of criminal case against Gandhi under various provisions of BNS, Official Secret Act, Passport Act and Foreigner Act. His claim was that Gandhi was the director of UK-based company Beck Ops Limited, and in its record he had declared his nationality as British. After the police failed to register a case on the complaint, Shishir moved the trial court. The complainant had earlier also asked the Ministry of Home Affairs to cancel the Gandhi's Indian citizenship on the alleged ground that he has already acquired a British citizenship. In August, the High Court directed the Union government to provide personal security officer of Central Armed Force to Shishir for his around-the-clock security. Another one news is employees hired without advertisement or interview cannot be regularized. सुप्रीम कोर्ट का ऑर्डर है कि एम्प्लॉई जो हायर किए गए विदाउट एडवर्टाइजमेंट और इंटरव्यू कैन नॉट बी रेगुलराइज इन गवर्नमेंट पोस्ट. Constitutional amendment bill to expand Lok Sabha strength to 850 fails to pass. Central withdrawal delimitation bills. Supreme Court का grant relief to businessman Venugopal Krishnan in rape case filed by ex-employee. Nitin Raj suicide accused teachers move Kerala court for anticipatory bail. How India's labor law exclude Asa Anganwadi and other workers by treating them as a volunteer. An employee hired without advertisement or interview cannot be regularized in Supreme Court case. The claim of being engaged since an advertisement itself gives rise to doubt as regard the manner of engagement, the court said. The Supreme Court has ruled that government employees hired on a contractual or ad hoc basis without any public advertisement or interview cannot be made permanent under state policy. A bench of Justice P.S. Narasimha and Atul S. Chandurkar passed the ruling on April 16 while striking down two notifications issued by Haryana government in 2014 to regularize service of a certain category of employees who had or were about to complete 10 years of service. The court said that the Haryana government failed to justify why services of such ad hoc employees who had not been engaged on the basis of any advertisement or interview were sought to be regularized. The claim of being engaged since an advertisement itself gives rise to doubt as regard the manner of engagement. Absence of any record whatsoever of the manner of engagement does not inspire any confidence in such process, the bench said. However, at the same time, the court acknowledged the practical reality that many of these employees had been working for a year. A period of almost 12 years has elapsed since the issuance of these two notifications. It is the specific stand of the state government that even after excluding the ad hoc employee from Group B, C and D who seek benefit of these two notifications, none of the posts advertised would be elected Further, it is informed that such appointees have now gained sufficient experience and are likely to have settled in life with the passage of time, the court noted. It therefore invoked its power under Article 142 of Constitution and allowed the employee to continue in service. However, it directed that they would be placed at the lowest pay scale applicable to their post. In 2018, the High Court in 2018 had struck down a set of Haryana government notification aimed at regularized Group B, C and D employees. The decision was then challenged before the top court, which ordered a status quo during the pendency of the matter. In the judgment passed on April 16, the top court modified the High Court ruling, while it struck down two of the notification issued in July 2014. It upheld the validity of two similar notifications issued in June 2014. The policies notified in June 2014 were aimed at extending the benefit of an older 1996 regularization scheme to employees who had been left out earlier. It noted the court found that the criteria prescribed was very much in tune with the criteria that would have otherwise been prescribed for regular recruitment. The criteria prescribed was not any manner watered down or deviated from the criteria required to be satisfied while seeking regular appointment. What is most relevant in our view is that such engagement should have been initially made on a sanctioned post, and such engagement on the sanctioned post ought to be continuing even on the date of regularization of service. This would clearly indicate that when such engagement on ad hoc basis was initially made, sanctioned posts were available and his positions continued for a number of years so as to enable regularization of service of the incumbents holding such posts. It said after pronouncing the judgment, Justice Narasimha remarked that the issue may require consideration by a large bench. We have gone through your suggestions. We had a particular difficulty being a combination of two judgments. It would have created yet another problem of two conflicting two-judge benches. We will keep everything ready. We will ask you to do a repeat performance at a time, perhaps when we get this matter taken up at a three-judge bench, which is necessary, and we are going to do that because we have seen that it cannot continue like this. Justice Narasimha said. The court places on record its appreciation for the assistance rendered by amicus curiae, senior advocate Nitesh Gupta and advocate Japneet Kaur, Janvi Dubey, Ashok Mathur, Vritti Gujral, M. Vikram Dwivedi and Jimut Mahopatra. Constitution Amendment and other one. In Khera's interim protection plea, Supreme Court on Friday refused Congress Pawan Khera's plea for interim protection from arrest till Tuesday and asked him to seek anticipatory bail from the court in Assam, where an FIR against him has been lodged. A bench of Justice J.K. Maheshwari and A.S. Chandurkar refuses to tinker with its order staying Telangana High Court grant of transit anticipatory bail. Supreme Court said invoke preventive detention against sand mafia. Supreme Court has expressed concern over powerful sand mafia operating in the country and said the state were virtually abdicating their constitutional responsibility to tackle the menace. The apex court said preventive detention could be invoked against the mafia. A bench of Justice Vikram Nath and Sandeep Mehta on Friday passed a slew of directions to MP, UP and Rajasthan, including installation of high-resolution Wi-Fi-enabled CCTV cameras on all routes frequently used for illegal sand mining and monitoring of footage. The law besides confiscations of vehicle and machinery used for mining. There is another case, woman jailed for falsely accusing husband of raping 16-year of daughter. A POCSO court in Itaha has convicted a 43-year-old woman of falsely accusing her husband of raping their 16-year-old daughter and sending him to jail in 2019. Special Judge Narendra Pal Rana observed that misuse of protective legal provisions cannot be tolerated under any circumstances. Any sentence the woman to 30 days of rigorous imprisonment. The court also imposed a penalty of 500 non-payment of which would result in an additional 7 days in jail. ADGC C. Krishna Yadav told that the case dated back to September 4, 2019, when the woman lodged a police complaint against her husband, then 40, accusing him of raping their daughter. An FIR was subsequently registered under IPC Section 376 and provisions of POCSO Act, following which he was arrested. The accused filed a bail plea stating that the case was fabricated due to a political conspiracy, but his plea was rejected due to the sections involved in the case and he was sent to jail for nearly 18 months. A charge sheet was filed in October 2019 and probe revealed that the woman had leveled the allegations against him over a family dispute. The man was acquitted by the court this January. There is another case which we know as Sukesh case. Jacqueline 6 to turn approval. Delhi court on Friday sought a response from Enforcement Directorate on plea by actor Jacqueline Fernandez seeking to turn approval in rupees 200 crore money laundering case involving alleged con man Sukesh Chandrasekhar. Special Judge Prashant Sharma issued the notice to the agency and listed the matter for hearing on April 20. The development come amid proceeding in the high-profile case where Fernandez was named as an accused for the first time in supplementary charge sheet filed by ED. The actor had earlier challenged the enforcement case information report before the High Court, which dismissed her petition on July 3 last year. Subsequently, Supreme Court also declined to interfere with the High Court's order, effectively allowing the investigation to proceed. Fernandez was summoned multiple times by AD during the probe. The case stems from allegation that the Chandrasekhar duped the wives of former Ryan Baxi promoters Shivendra Singh and Malvinder Singh, approximately Rs 200 crore. Chandrasekhar, his wife Lina Paulos and other accused routed proceeds of the crime through Hawala channel and parked the fund using a network of shell companies. Both Chandrasekhar and Paulos were arrested by Delhi police. ED has alleged that the Fernandez received gift worth up to rupees 7 crore from Chandrasekhar. It said she may have been aware of his criminal background and allegation she has denied. Another case, conversion case. No High Court relief for student. Allahabad High Court has refused to quash FIR against two class 12th students under UP anti-conversion law for alleging forcing a classmate to wear a burqa and trying to convert her to Islam. The High Court noted that the alleged defense The High Court noted the alleged offence reflected a disturbing trend of young people thrusting their religion belief upon others, a tendency sought to be curbed by the UP Prohibition of Unlawful Conversation of Religion Act 2021. If this trend is prevalent among young people, it is all the more disturbing. This is the time when they should be thinking more towards developing their skill in different field and dedicate themselves to the service of society and nation. Justice J.J. Munir and Tarun Saxena observed Thursday as they dismissed a quashing petition by accused Alina and Sabia. The bench noted that the material collected during the probe case diary, including CCTV footage showing the victim being forced to wear the burqa by the accused, prima facie discloses details that require a thorough investigation. It noted that the 2021 law was enacted to curtail an emergent mischief, and the same cannot be subverted by snuffing out prosecutions brought on tangible material at the threshold. The FIR was lodged on a complaint by the brother of the victim, a class 12th student in Muradabad, alleging that his sister was compelled by 5 Muslim classmates, including the petitioners, at the tuition center in 2025 to wear the burqa and embrace Islam. The victim alleged that the classmate would bring non-vegetarian food and ask her to have the gravy. When she refuses the meat, she claimed that one of them brainwashed her to be extended, that she lost her ability to think. She alleged that they would repeatedly tell her the religion was good, that the Quran could be read in 14 days, and wearing a burqa offered the freedom to go anywhere. Sabia's counsel sought the FIR quashing, saying it carried general allegations and was a counterblast to a stalking complaint by one of the accused against the victim. The brother Allahabad High Court said whether the act of the accused constitute allurement or undue influence punishable under the 2021 Act was a premature question in FIR quashing plea.